I'm excited to introduce our speaker today. If you had the opportunity of joining us during any of our last sessions, you would have gotten some great tips, and thank you for joining us again. Now our presenter is Callan Soldevini, Esquire, Callie. She is a public interest attorney who is dedicated to helping those with unmet legal needs. Through her career, she worked as a transactional business attorney and a civil prosecutor. She wears many hats in the community and is an advocate for the underserved areas. Her goal is to promote economic development and to stimulate growth in our communities. She teaches courses in ethics, business law, corporate social responsibility, and conflict resolution. Currently, she is with the FCDL as an attorney at Legal Aid Services of Collier County and Broward. And of course, she's here with us today during our program. I am so happy to have her. Please join me in welcoming Callan Soldevini. Callie, you can take it from here.
Good morning, everybody, and thank you so much for joining us this Thursday afternoon as we talk about something I'm sure everyone in the room has experienced, and that is issues that come up with commercial leases. And I'll talk about several just common things to look out for in commercial leases, but also some considerations after COVID. And before I get into the specifics, I want to talk about the program that I work for called the Florida Community Development Legal Project. And this is a wonderful resource because it provides free legal representation to two types of clients. One, which is what I'm sure most people are in the room for, small businesses that are owned by low to moderate income individuals. And that is up to 140% of your area median income. So for example, in Broward County, a family of one, that's about $70,000. For a family of four, it's over $90,000. So we do have a lot of wiggle room to be able to serve clients for free. And then we also, worth noting, serve nonprofits that serve low-income communities. And some of the examples of free legal services we provide are incorporation if you're just starting out. And if you are just starting out, I highly recommend that you reach back out to Black Swan Events and look at a previous segment we did on the different kinds of business entities, and that may help you determine which one is best for you. Or if you ideally qualify for our free legal services, we would be able to represent you to start your business, incorporate it, and draft your internal operating document. We also do trademarks, partnerships agreements, contracts, leases, a dispute resolution. A lot of right now that I'm doing during COVID is representing clients and negotiating either lower rent or lease terminations with commercial landlords. Template client agreements, if you regularly use an agreement. I promise anyone you bought on LegalZoom really should be reviewed by an attorney, and more. What we really try to do is, for our eligible clients, act as their in-house counsel. And if you're able to focus your time and energy and money on running your business, you're going to be able to hire more people in your community. You're going to be able to have a successful and long-standing business, a business that makes it through COVID. And that's really the point of these free legal services and the essence of our program. So if you believe that you may qualify, I will have my contact information up, or you can reach out to Sidoni and Black Swan Events and see if we can help you out with your legal needs for your business or nonprofit. And then, as a quick disclaimer, I will talk about a lot of legal concepts throughout this presentation as it relates to commercial leases. However, this is only to convey general information and not provide any specific legal advice or opinions. So everything is case and fact specific, especially with commercial leases. A lot of times I'm going to be talking about what Florida statute says, but your lease might say something different. So it's really important to look at the exact terms of your lease and ideally qualify with or retain a qualified attorney to talk about the specific matters that are going on. So a few items before you actually sign your lease. And this is really, this is really important because this is overlooked a lot. And especially when you get a really good deal for a lease and you're like, oh, this is in my budget. It's even bigger than I wanted. It's in the perfect place. It serves all my needs. People are really ready and quick to sign a lease, but sometimes if it's too good to be true, it is. So one thing to do is identify problems that should be fixed before signing the lease. So go into the property if possible. Take pictures and videos and notes of questionable conditions and bring that to the attention of the landlord to either repair before you sign the lease, or if you need to sign the lease, if things are moving quickly, put a provision in there that says these are the items that need to be repaired and include that in the lease or a separate agreement. Because once you sign the lease, that's it. And the landlord, unless they are a really, really nice person, probably won't do much about it. Next is to make sure the premises is right for your intended use. Are you a hair salon? Are you just simply it's a desk job? Is it something where you need the premises to be able to work for your specific occupation? So before you sign that lease, take a look at the premises, talk to the landlord about exactly what you're doing, and make sure that the unit is intended for your specific business. Because commercial landlords are not obligated to ensure the fitness or suitability of the property that you're leasing. So unless there's a clause stating so in your lease, or it's a brand new building, and still even that can be questionable, you want to make sure that you say, I'm a hairdresser, I need to make sure that I have 3 shampoo bowls and this many electric on the other side for X, Y, and Z. And make sure that that's in the lease what the intended use is, and that the landlord agrees that the unit will work for that. Some legal considerations. Commercial leases may or may not be negotiable. So a lot of times if you're leasing in a large building, or a building that's owned by a large developer that may not even be located in Florida, they may say, this is the lease, take it or leave it. I would still recommend to make reasonable changes and see if they're accepted, because that happens a lot. They say something's not negotiable and you just tweak a couple of things to make it more fair to you as the tenant. But sometimes it is what it is. Other times, of course, the landlord will allow it for you to negotiate terms. But if they don't allow you to negotiate, it's really important nonetheless to understand what you're agreeing to. And trust me, I understand. I absolutely hate reviewing leases. They're like sometimes 25 pages. Oh, good lease should be 25 pages. And dry and dull and talks about all of these things that you're like, this won't happen to my business. But it's really important you understand everything that you're agreeing to, because if you don't understand and you sign it, that's it. Even if you find out 2-3 days later, there's no grace period allowed for canceling the lease. So if you sign it, you're bound to the terms within it. So just like any other document, you want to make sure that you truly understand what is being required of you under your commercial lease. You also want to be careful about deposits, and this is a really sticky situation because whatever, you should have some agreement in place before you hand over your deposit, and it should be stated in the agreement whether or not the deposit is non-refundable. So if you do pay a deposit and it's before your lease term starts and you realize the unit isn't fit for what you need, the language in the agreement will spell out how to handle that. And you want to make sure that if you are giving a deposit and it is non-refundable, that you're really ready to not see that money come back to you. Also, personal guarantees are a really, really big risk. One of my other presentations with Black Swan events discussed the benefits of incorporating a business and separating liability. In the shortest, most plain terms, if you incorporate as an LLC or a corporation, as opposed to a sole proprietorship or a partnership, you do have to pay these fees to the state to register. You do have to keep up with certain document record keeping and other things. But instead of, if something happens and you aren't able to pay your commercial lease, and you are an LLC or corporation, it's going to be much more difficult for the landlord to go after any of your personal assets, because when you incorporate, your business assets are separate from your personal assets. Just similarly, your business debts are separate from your personal debts. The problem that landlords know is that you may not have a lot of capital or assets in your business. So they may ask, especially for the first time you're entering the lease, for a personal guarantee. And this is a really big risk because you're essentially personally guaranteeing with your personal assets to be able to, that if the landlord needs to sue you for unpaid rent, that they can attach to your personal assets or whoever you have sign your personal guarantee. So it's extremely risky. It's pretty reasonable for landlords to require this, to be honest, if you're a new business or it's clear that your business doesn't hold a lot of capital or assets. However, if you've already been in a commercial lease and you have a trust with your landlord, and sometimes they will, 5 years after you've been in your lease, they'll come and ask for a personal guarantee. I recommend stating that you've been there for several years and you've been in business, and why would they bring this up now? It might be an attorney telling them that they need this. It might just be that they want their new tenants to have it, but you can try your best to get out of it. But if you do enter into a lease with a personal guarantee, know that there's a lot more risk involved in that. Let's get into some specific lease terms, because commercial leases under Florida statute are pretty detailed, and Florida statute has some pretty weird requirements. And one is, this one is actually expired now. Florida statute up until July required, no, this one's still good, never mind. Florida statute requires if the lease is over a year, it has to be in writing. So you don't want to miss that step and say, oh, this is just you can have an oral lease, but it can only be for under a year. So maybe it's month to month or every 3 months you're renting something, that's okay. But if it's over a year, to protect yourself, you should put it in writing. Next, another Florida statute requirement is that notices to and from the landlord must be in writing and must be hand-delivered or mailed, hand-delivered or mailed, even if the rental agreement is oral. So really the point is that if you need to prove that something happened, you can show a judge a letter, a notice that was given to you by your landlord, and vice versa. So it's really, really important, because this is Florida law, that you always retain copies of any correspondence to and from your landlord, because it may be important to have to prove something.
And Callan?
Yes.
Yes, hi. I know you don't mind. We do have one
Okay.
question that came in, and it's related to personal guarantees.
Sure.
And I know you don't mind answering throughout the program.
Absolutely. Everyone feel free to interrupt with questions.
All right, sure. All right, so it says, I have 2 partners and we are looking for a commercial space. They ask for a personal guarantee. Are my partners also liable if I sign?
And you said you were in a partnership?
So it says that they have 2 partners
Mm.
and they are looking for a commercial space, and they're asking, the landlord, I'm assuming, is asking for a personal guarantee. Now they're asking if their partners are also liable if they do the personal guarantee. Is that something that you could touch on, or would it require for all of the partners to sign that personal guarantee as well?
The landlord may require all partners to sign it, or they may just be looking for one. And this is tricky without actually looking at the personal guarantee or knowing the exact situation. But generally, if you sign as a personal guarantor and you're in a partnership with other partners, and that personal guarantee relates to the business that you are doing with your partners, and for some reason you're unable to pay rent, and the landlord comes after you individually as well as the partnership, you can actually try to get that money back from the partnership, because even though you personally guaranteed it, that's really just something with the landlord so that he or she is protected in case the partnership can't pay rent. But if you need to go after your partners for that sum, that's probably how that relationship would play out. It's really the landlord looking for one of you to be responsible, but that individual that's responsible can also collect from the partners if that ever occurs. And then I'm not sure, partners is a general language, but if you are a partnership and you are two or more of you are operating a business, I would also look at the liability protections of an LLC or corporation. And again, that's a previously recorded that Black Swan Events will have up on their website.
Thank you.
Yes. Then going back to some lease considerations, you want to be pretty comfortable with the terms of the lease and make sure everything is included. You want the term, what's the start and end date, exactly what's the security deposit, what are the late fees if you are late with rent, 5 days late with rent, 30 days. How can the lease be terminated? Can you pay 3 months of rent as a penalty to get out of the lease, or is there no termination language? Who's going to take care of utilities, electric, trash removal, internet, gas, phone? All of that should be stated in the lease. Of course, insurance requirements should be stated in the lease. That is heavily negotiable. You can have the landlord take all the insurance or you, but commonly it'll be both the landlord and the tenant that should have it to make sure everyone's adequately protected and can sleep well at night. Maintenance, repair, and improvements. We'll talk about two kinds of leases and generally who's responsible for that, whether the landlord or the tenant. And something that's often overlooked, parking. You want to make sure that whatever kind of business you're running has adequate parking, and you want that to be spelled out in the lease. You're entitled to X amount of spots or X percentage of the parking lot. And under Florida statute, landlords and tenants have specific duties, and it seems really obvious, but it's worth mentioning that under Florida statute, no matter what the lease says, the landlord must deliver possession of the premises at the time specified in the lease. So if it's your lease start date and the landlord says, oh gosh, the last landlord's still not out, can you push it a week? They're technically in breach of the lease. So they need to deliver possession at the time specified. Or if they said, oh, I'm still cleaning or I'm still trying to make repairs, again, that's technically a breach of the lease. And second, the landlord must provide quiet enjoyment. And that just means that the landlord is ensuring the tenant that they have clear title, and meaning they properly own the leased premises and there's no defect in the title. And that just ensures that you as the tenant aren't going to be interrupted by someone who claims that they own the property and they want you out of there. The landlord is claiming, I own the property and no one is going to interrupt you being able to lease it from me. Next, the tenant has certain responsibilities under Florida statute, and the most important, it seems obvious, but sometimes it's not apparently, is to surrender the possession when the lease expires. If you want to stay in the lease, you should negotiate, even if it's a week later, you should negotiate that with the landlord. The last thing you want is the landlord charging you way higher rent for that holdover period. Pay rent, so including after sales tax, if that's what's stated in the lease. And then you should also include, sometimes life happens and you need to be a few days late. What happens if rent is late and what the late fees might be. So paying rent and returning the premises in the same conditions when the lease started. And this is a point of a lot of litigation because the tenant has to give the landlord back the premises in the same condition. However, except for normal wear and tear. Normal wear and tear is really difficult to define. If your lease was 1 year and your unit looks decrepit and has holes in the walls, that's probably not going to fly. If you've been in the unit 10 years and the floor is no longer good, and that's different. So it's very fact specific, but it's just what you would expect as normal wear and tear. But again, this is a big point of litigation because a lot of times landlords will say this is worse than normal wear and tear and I'm going to sue you for you to fix it. So you just want to do your best to leave it in the best condition as when you got it. So that means, especially if you do a build out, that you repair holes in the wall, repair dents in the floor, do your best to leave it in clean and broom clean condition. Make it very hard for the landlord to argue that it wasn't normal wear and tear. And then, as I mentioned, we're going to talk about two types of commercial leases. And you can have a modified version of both of these leases, but typically the two kinds are, first, a gross lease, and that's where the tenant will be responsible for paying rent until they are doing, tenant will be responsible for paying the rent for the unit they are doing business in, but, of course, base rent, but the landlord will need to cover insurance, taxes, and expenses for the common spaces between the other businesses if it's in a building. So that's great, but your rent's going to be higher. Then there's a triple net lease, and that's where the tenant is going to pay insurance, taxes, and additional expenses. So this is going to be stated in your lease, and you want to make sure that you understand that and you're comfortable with it. Because if you have a triple net lease and the air conditioning breaks, you could be out several thousands of dollars. If you have a gross lease, you're paying higher rent, but if something happens to your HVAC, it's going to be on the landlord to repair. But then again, you can also draft and work with the landlord to create a modified version of the two. A lot of times, this is the issue my clients have. There's a failure to pay rent. Whether it's COVID or before COVID, life happens, and failure to pay rent is a breach of the lease and a violation of Florida statute. And Florida does not have very favorable laws for tenants. Generally, they favor landlords. Non-residential tenancies are covered under Section 83, Part 1 of Florida statute. So if you're not sure what to do, first of all, if you qualify for our free legal services, contact us. If you don't qualify, look up Florida statute Section 83, Part 1, and that applies to non-residential tenancies, so commercial leases. And these are, it explains that if a tenant fails to pay rent, landlord has the right to recover possession of the premises, but only under certain circumstances. One, upon delivering 3 days written notice to the tenant for the payment of rent. Two, if the tenant surrenders possession, so if the tenant just leaves. And three, if the tenant abandons the premises. So again, none of those things say a landlord can just come right in and take it back from you. They have to provide notice, and they have to do it under Florida statute. So if you do have a landlord that's threatening you and saying, I'm going to barge in there, I'm going to take your things, I'm going to lock the doors, they can't do it unless, again, they do it in one of these three ways. Upon delivering 3 days written notice for payment of rent, or of course, if you as the tenant surrender possession, or three, if the tenant abandons the premises. So if they are threatening you, that is a threat, and that's absolutely something they can't do under Florida statute, and it's probably worth retaining or consulting with an attorney about that. When can the landlord consider the premises abandoned? If they have reason to believe the property has been abandoned for 30 consecutive days, of course, without rent. You know, if the hurricane hits or COVID happened, there's going to be a lot of commercial units that aren't going to be there for 30 consecutive days. But if they're paying rent, it's not considered abandoned. And that notice was served and 10 days have elapsed since the service of such notice. So really the point of this, landlords cannot just come in and cannot just take the premises back for non-payment of rent. They do have these steps to follow, and if they violate these steps, they violate Florida statute. And now we can talk about failure to pay rent and the landlord's remedies under Florida statute. And this is where, when I say that laws really aren't favorable to tenants in Florida, this is what I mean. If you as a tenant aren't able to pay rent before COVID or now, what happens? First, the landlord has the right to file suit for unpaid rent until the end of the lease term. So if you have several years left, that puts you as the tenant in a very vulnerable position. Generally, a court will require that the landlord uses his or her best reasonable efforts to release the premises, but that's really, really hard to enforce. And what if they can only release it for a lower amount of rent? Or what if because of COVID, they aren't able to find new tenants? So just as a cautionary tale, just pretend that the landlord has the right to sue for unpaid rent until the end of the lease term. If the end of the lease term is 1 month, that's not too bad. But most of the time it's going to be several years, and that puts you in a very, very risky position as a tenant. Next, the landlord can lien the property in the leased premises to cover rent. So if you have valuable equipment, the landlord under Florida statute has a right to lien that property so that they can use it to help pay for unpaid rent. So again, taking that property and leaving it in the middle of the night also puts you in a very vulnerable position, because if the landlord does decide to pursue a lawsuit, the judge is not going to react well that you disappeared and took all of the property that the landlord had a right to lien. The landlord under Florida statute can lien other property of the tenant. So as I mentioned earlier, if you are incorporated as an LLC or Inc., you're going to be far better protected. If you're currently entered your lease as a sole proprietor or partnership without liability protection, again, reference that previously recorded lunchtime series, you're in a really vulnerable position, because under Florida statute, the landlord can go after other property besides just the equipment within the leased premises. But you're much safer if you are incorporated. And finally, many landlords will require the tenant to pay the landlord's attorney's fees under the terms of the lease, because landlords don't want to have to pay thousands of dollars for attorney's fees to collect, say, $3,000 to $7,000 from their tenants. So normally, if they're a smart landlord, they're probably going to say that if the landlord sues for unpaid rent and is successful, that the tenant will pay the attorney's fees of the landlord. So just imagining where you're at in your commercial lease now, or have been, this puts a lot of liability on you as the tenant, and it's just worth it to attempt to negotiate with a landlord, especially after COVID.
And hi, Kelly.
Yep.
I have two questions, actually. One is really quick. It goes back to the triple net that you mentioned.
Mm-hmm.
So it says, I noticed in South Florida, many landlords uses triple net. Why is that? And, you know, as a realtor, I can relate to this question, a commercial realtor, because I some of the office buildings, mostly freestanding retail properties and office buildings, I know that usually are triple net, and it really depends on the type of building. But I'm going to let you, the expert, answer that one for sure. So the question was, I noticed in South Florida, many landlords uses triple net. Why is that?
Well, just like a gross lease sounds a lot easier for a tenant, depending on the condition of the building, a triple net lease might be way better for the landlord, because they don't want to deal with having to pay insurance or taxes or fix things in the unit. But it really just is a preference. It's up to you to negotiate it. This is probably something a landlord won't be willing to negotiate. But if a landlord doesn't really want to be hands-on, they might lean more towards a triple net lease as opposed to a gross lease. But that's just from a legal perspective and obvious perspective. But Sidonia, if you have any commercial real estate, just practical guidance, that might be able to help answer the question as well.
Yeah, like I said, a lot of it depends on the type of building and what's customary in Florida. You see that in a lot of retail spaces and a lot of office buildings, mostly. Some warehouse and clubs So mostly where you'll see a gross lease is usually a larger industrial type of building. You'll see that mostly. So that's that's my answer on that one. The other question that we have is that I have a sublease under another renter. I recently found out that he was not allowed to sublease. We like the place. How can we get the paperwork from him? We do pay rent every month.
Yeah, that's very common that most most landlords will put in a commercial lease that either they'll put a flat line, no sublessees, or they'll say that a sublessee has to be approved by the landlord. And really they're just making sure it's not, a business that would make them uncomfortable or risky or something like that. If you are considering a sublessee for everyone else, you want to see the master lease, the lease between the original landlord and tenant. And you want to make sure that it allows for sublessees. Then you would enter into a new separate lease if it's over 1 year to sublease that premises. And if you're already established and paying rent, one way to, and you want to stay there, one way is to just probably communicate with the landlord if that seems best in your particular circumstances, because if the landlord does have a problem with it, he can go after the original tenant that you're leasing from and collect damages or file suit. But if you're paying rent on time and you're not a business that would harm the plaza in any way, if it's a plaza or the building in any way, or it's not violating, oftentimes in the master lease, it will say that, that they can only operate their certain kind of business. If your business is different than that, it may be in breach with another lease that the landlord has within the building. For example, there can't be more than one restaurant, there can't be more than one nail salon, whatever it may be. So it is a really sticky situation to get in, but I think that the best thing you can do at this point is first take a look at the master lease, request that from the original tenant, see what the terms are, if there's anything that might rock the boat, and if there isn't, then maybe the three of you meet and just be honest and say, sorry, we didn't understand the terms of the lease. Would you be willing to allow me to continue to sublease, or can I just lease from you directly? But yes, sublessees, there's a lot of risk involved there, and it's just best to probably get on the same page if you can, rather than being stressed every night you go to bed whether you're actually allowed to be in the premises or not.
And Kelly, would they be allowed, would they be able to demand, so to speak, some kind of paperwork from the person that they're actually paying rent to?
I'm not sure about that, but I'm not 100% sure, but I'm as sure as I can be that absolutely the subtenant can demand the master lease from the original tenant. Absolutely, because that just public policy makes sense, because, what if they're charging you 3 times more of rent? Really, the original tenant should have just included the master lease in your agreement and held you as the new subtenant to all of the same terms and conditions that they're held to in the master lease. If not, then there's just so much room for liability for that original tenant. So I don't know that if there's like a specific law that would require it, but I assure you that under public policy, it makes sense that you should be able to demand the master lease.
Thank you.
So a couple more points. One last point before we move on to a few COVID-specific related issues that have come up a lot in my line of work. And that's limiting liability under the lease. I mentioned it, but again, this is really important. If you operate your business as an LLC or corporation, enter into the lease under that entity and not your individual name. Because if you enter, even if you have an LLC or Inc. and you have all that liability protection, but you enter the lease as John Smith, technically you contracted as John Smith, not ABC Inc. So make sure that you're entering in that this applies to all agreements, not just leases, that you're entering into your agreement as the entity, because really that entity is its own person. You're just the president of it or the manager of it, whatever your role may be, even if you're the sole owner. Next, again, I can't stress enough, if you are not incorporated, consider incorporating, so in case you do breach your lease, you're limiting your liability and exposure that the landlord can collect. And this has been a really, really hard time. I'm sure that anyone that is in a commercial lease during this time, I'm sure how difficult everything has been, not just due to business closures, if your business was forced to close, but things are just slowing down for most industries. And I think this is really important to share some things that have come up for me that have helped my clients, even though they're not necessarily legal. So I'm sure as everyone's aware, on April 2nd, Governor DeSantis issued an executive order imposing a moratorium on evictions. However, this was only imposed for residential tenancies, not commercial tenancies. As such, commercial tenants have been afforded very little protection besides even if businesses shut down. So if you were in an industry that had to shut down, there's really nothing in place besides the PPP loans and the SBA loans to help you at this point. And it doesn't change in any way the legal relationship that you have with your landlord or the requirement to pay rent on time. And that's really, really harsh. So I have just gathered some advice for tenants, because most of the time I can't really help my clients that say, I can't pay my rent and I'm scared my landlord is going to sue me. But I can't pay it because I don't want to, or because I spent it on this awesome new boat, but because I haven't been able to actually gain revenue and I don't have any money to pay rent. So my advice is that although the law is more favorable to landlords, tenants still have some protections. And if you are a commercial tenant whose business was forced to close, here are my few tips. Review your lease. If you can, consult with an attorney, but look at it and see if there's what's called a force majeure clause. And a force majeure clause excuses a landlord and tenant's performance due to unforeseen circumstances. And I think we can all agree, no matter what we feel about COVID, it was unforeseen. If your lease has a force majeure clause, it's pretty much just going to say landlord and tenant don't have to fulfill the obligations under this lease for sometimes what's called acts of God, so that could be a hurricane. But if it's under Florida statute, it's very specific. It has to specifically state the reason that excuses the performance, so meaning excusing paying rent. So make sure if it says pandemics, diseases, public health emergencies, national pandemics, or something to that effect. It's most of the time these are not in leases, but it's still worth looking through and seeing if they are. Again, that's called a force majeure clause. A second tip is business interruption insurance. If you purchase business interruption insurance, which a lot of commercial leases require, see if qualified business interruptions like natural disasters or government actions are covered. I haven't had success with this yet, or haven't had a client tell me that they've had success with it, but again, that's one other road to go down. And really here are the only two options for a commercial tenant at this point. Talk to your landlord about creating a repayment plan. At the end of the day, you don't really have a great legal argument. I had a client that wasn't able to pay rent. He owned a barber shop in Golden Gate in Collier County, and he just said, obviously I can't pay rent. But I'm sure if I go to the judge and I tell him how hard I tried and how I tried to save my money and how I can't keep up even when my business reopened. A lot of his employees moved back home because they weren't able to continue paying rent. The judge has to understand I have to feed my family. They absolutely don't. A judge, he or she may sympathize with the situation, but at the end of the day, their duty is to enforce the law, and there is no law in place at this time, and highly unlikely that there's one on the horizon where commercial tenants have to work with their, or excuse me, commercial landlords have to work with their tenants. So remember that landlords, that their agreements are mutually beneficial. So negotiate with your landlord or reach out to us if you qualify for our services, and we'll do this for you. Let them know. So here's when I call, this is what I do. I say that it's a mutually beneficial for the tenant to be able to remain in the lease, because the tenant wants to remain in the lease and the landlord wants to collect money. Tenants hope to survive temporary shutdowns so that they can continue operating their businesses once activity resumes and picks up. So removing them removes the possibility of future payment. And moving in a new tenant it's very unclear if they're going to actually be able to survive COVID as well. And then in return, landlord hopes that tenants survive so that they can continue to collect rent payments in perpetuity. Maybe tough for landlord to find a new tenant for businesses right now, because it's not like renting a new space is at the top of most industries' to-do list. So just really at the end of the day, it's appealing to their humanity, while you as a tenant are also understanding that they have a contractual right to the money for the rent due until the end of your lease term, and that they do have mortgages to pay. They'll have to pay the electric and utilities and water while no one is in the building. So, being reasonable as possible and appealing to humanity. If you can't stay in the lease, you don't want any months forgiven, you just want to, retire, or you aren't able to operate your business. There are a lot of industries that we don't see turning back around. I have a lot of friends and clients in entertainment and in live music and in sports and hospitality, and it's not really clear when that's going to resume back to normal, whatever that means. And you just need to end the tenancy. Again, appealing to humanity, the landlord's humanity, and explaining that will get you far, and hoping that the landlord has applied for some kind of loan to help them get through this. But again, a loan, they typically at this point have to pay back, and with small interest. So just understanding that they have duties and obligations too, and both being as reasonable as possible given how difficult life has been since COVID for business. And finally, apply for federal, state, and local assistance programs. Here and there I have a lot of clients that are like, I want a grant, and meaning they don't want a loan, they don't want to pay it back. And I wish I had a lot of those available, but they were pretty sucked dry at the beginning. There is one for small, so when I come across them, I send them out to my clients, or I send them out to others that may have clients. And I did just come across one yesterday and it's only for women-owned businesses, called the Sorensen Grant. No, I think that's a different grant, but so I did email it to Sidoni, so she does have that information. So if you are a woman-owned business, then it's a $4,000 grant, so you don't have to pay it back. And really, it's just looking for stories of, how you got through COVID, especially if you do anything good for the community, if you're green, just like a happy, warm, fuzzy story. But $4,000 can be truly helpful at a time like this. But besides that, I haven't seen another grant in probably 2 months that would be widespread for small business owners. So you want to look at federal, state, and local assistance programs. Look at the PPP. If you've been denied, I have a lot of clients that were denied, try going to a smaller and more community banking institution rather than Chase, Wells Fargo, Bank of America. Go to your Florida community bank, and if you, we can also represent you to help you with that information if you're eligible. So if you have any other questions, again, my name is Counsel Davini. I am a staff attorney at Legal Aid Service of Collier County. I discuss the free legal programs and services that we provide. I provide them in Collier County and Broward County and Lee County. However, we have attorneys located throughout the state. So I did see one of the participants today is from outside of Florida. We don't do anything outside of Florida, but if you are doing any business anywhere in Florida, we have an attorney that, if you're eligible, that should be able to represent you. Thank you.
Wonderful, wonderful. And to touch back on the grants and that you just mentioned, Callan, there is one that's it's a RISE program. And what they do is they offer, if you have been declined for a loan, they actually do, look at your situation. At least they required that your credit is at least 500. So they're being pretty lenient with that. And they provide a loan and up to, I think, $10,000 for small businesses that are in need of that. There was another grant that was the Lowe's grant that just passed. Every now and then they actually do have a session where they do a rollout, a series of them. They've done one for at least 5 times now, I've seen. And of course, the third one is that you mentioned that you sent to me, and I have sent to most of my clients, and I continue to send to people that I am connected with. So
great. And that one's called the Amber Grant, I think.
The Amber.
And then just something before I forget, if you do take the PPP loan, and I think the SBA loan, there are so many resources out there. SBA has webinars and that they'll help you with the tips and stuff to fill out the application. And right now I'm advising any clients that do receive that funds, including my family who is not, who wants to use it for non-business related expenses. There is a possibility that it will be forgiven. Possibility. So if you want to document and show that you're using that to be able to pay rent, pay your employees, pay your staff, pay third-party vendors, try to keep records of that on the off chance that this is forgiven, that you can show you actually did use it to get your business through COVID.
All right. Wonderful. If you don't mind, you could just stop sharing on your end, and then we'll just take over control again. All right, so there we have it, everyone. Thank you so much for joining us for this session. Our next session is going to be on intellectual properties, which everyone should, basically, if you're in business or if you intend to have any kind of a brand or so, this is such an important topic. It's part of one of the things you want to get done from very early in the stage when you are planning for your business. That will be on August 20th. And then the following week after that, we're going to have a session on insurance. And the idea is to have 2 sessions. So one will be specifically on commercial insurance, and the other one will be on bonding, which is a topic that I have spoken to so many clients about. A lot of times when you deal with government contracts and you even offer services, sometimes you don't think you need to be bonded, but that's not the case all the time. So we'll have the experts come to you. That's the idea of this lunchtime series. And I hope that you have found this program helpful. And thank you again, Callan, for your time and your efforts. You have been phenomenal. And we do certainly appreciate your partnership and everything that you are doing for the community as well. So everyone, I would say be safe and don't worry about a thing. Until next time.
Bye, everybody. Thanks for your time.